I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 79th lecture series. We have gathered here to discuss about the authoritative pronouncement of the Honorable Supreme Court related to Article 370 of the Constitution of India. Before going to the topic, it is our regular practice that we recite the preamble of the Constitution of India as our daily prayer. Because we strongly believe that preamble our identity, preamble our unity, preamble our sentiment, preamble our commitment, preamble our goal, preamble our soul. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. We have previous videos on Article 370. We have discussed about the overview of the entire judgment. Secondly, we have discussed about how the case was decided, came to be decided by the Constitution bench, that is comprising of 5 honorable judges. And the next video is about the conclusion, authoritative pronouncement. It comprising of almost 13 points. We have covered 5 points and the remaining points is yet to be covered. But to give a brief background, a very brief background about the case, I will take you to Indian Independence Act 1947. When our India was ruled by the Britishers, they passed an act called Indian Independence Act 1947, by which Dominion of India, Dominion of Pakistan was made. There was a liberty given to the princely states to stay neutral or to be with Dominion of India or with Dominion of Pakistan. So state of Jammu and Kashmir, it was ruled by Maharaja Hari Singh. He wanted to remain independent. Later on, when he found that he is going to be attacked or acquired by the Dominion of Pakistan, he sought the help of India. At that time, our leaders said, if you want to be with us, you have to sign instrument of accession. So that was signed, and state of Jammu and Kashmir has become a part of India. Moreover, there was that special privilege given to the state of Jammu and Kashmir by virtue of Article 370 of the Constitution of India. So this special power continued to enforce very recently, that it was abrogated. The special power given to the state of Jammu and Kashmir was abrogated by the presidential orders, Constitutional Order 272 and Constitutional Order 273. So why, when abrogation was done by the president, his action was challenged by the petitioners before the Honorable Supreme Court under Article 32 also and under Article 136 also. Majorly, the challenge was that dissolving the Legislative Assembly by the governor under Section 92 of the Constitution of Jammu and Kashmir was challenged. The other challenge was promulgation of state emergency by the president in the state of Jammu and Kashmir that was challenged. Then constitutional order pronounced by the President of India, Constitutional Order 272, Constitutional Order 273. What is this 272 says? By Constitutional Order 272, the President has declared that entire provisions of the Constitution of India will be applicable to the state of Jammu and Kashmir. Previously, entire constitution provisions were not applicable. But through this Constitutional Order 272, the President made applicable the entire provisions of the Constitution to the state of Jammu and Kashmir. What is the effect of it? The Constitution of Jammu and Kashmir became redundant, useless, meaningless. This was challenged. Thereafter, Constitutional Order 273, by which the President of India has abrogated the special powers vested with the state of Jammu and Kashmir. So these were the two orders were also part of the challenge before the Honorable Supreme Court. Now the Supreme Court has pronounced a judgment running to several pages, more than 300 pages. But authoritative pronouncement that you will find it in the conclusion. Each point behind the conclusion is 280 or 285 pages to arrive at that conclusion. So therefore, let us keenly understand each points and understand and what is the ratio decidenting behind passing this authoritative pronouncement, that also we will see, dear friends. This got reported in 2024 volume 11 Supreme Court cases, page 1, and this was decided by the Constitution Bench judgment comprising of honorable 5 judges. I will take directly to para 531, which deals with the conclusions. Already the 5 or 6 points are already covered. I will not take your time by taking again to those relevant paragraphs. I will start from where I have left. Point number 6, the paragraph number, please make note of paragraph numbers, that will be very helpful. 531.6, paragraph 531.6. The power under Article 370 Clause 3, I read and then explain. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370 Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370 Clause 3. See, the most important article is 370 Clause 3. What does it say? The President, by notification, by public notification, declare that this article, that is Article 370 of the Constitution of India, shall cease to exist. And they can specify certain time also when it ceases to exist. Or they can prescribe certain conditions also. Based on these conditions, Article 370 will cease to exist. This is the main provision under Article 370 Clause 3. The President may declare by notification saying that this article shall cease to operate, provided there is a condition, provided that the Constituent Assembly makes a recommendation for that. Let me read 370 Clause 3, dear friends. Article 370 Clause 3, notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article, which article? Article 370, shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as he may specify. Provided, this is important, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 of Article 370 shall be necessary before the President issues such a notification. So the President can declare that this Article 370 shall cease to operate only when there is a recommendation from the Constituent Assembly. Now the question is, this Article 370 special powers were provided when the Constitution of India was adopted and enacted somewhere in 1950. But the Constitution of the Jammu and Kashmir that was drafted by the Constituent Assembly, once it was drafted, the Constitution was drafted, the purpose of the Constituent Assembly got dissolved. So the petitioner says, Constituent Assembly got dissolved. Therefore, the entire provision has become redundant. The entire provision, that is 370 clause 3 main provision also, proviso also has become inoperative. That is their contention. But the Honorable Supreme Court has divided a wall between the provision and the proviso. This is where you can see, understand the rich experience of the Honorable Judges, wisdom of the Honorable Judges. Because they have divided the wall by saying, the proviso is dead. It has become redundant. The recommendation by the Constituent Assembly is not there. It is dissolved. Therefore, when it is dissolved, where is the question of making recommendation to the President? So, proviso is dead. Constituent Assembly got dissolved. But now, without the recommendation of the Constituent Assembly, the President can act independently. That main provision is still existing, is still operative. So that is what they have held, dear friends. Let me read now. In light of this explanation, let us see again paragraph number 531.6. The power under Article 370 clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370 clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. Only proviso ceased to exist, but main provision still it is operative. Therefore, President in his individual capacity can publish, can declare that this article shall cease to be operative. It did not affect the power held by the President under Article 370 clause 3. I am moving on to the seventh point. Article 370 cannot be amended. Article 370 cannot be amended by exercise of power under 370 clause 1 subclause D. Recourse must have been taken to the procedure contemplated by Article 370 clause 3. So what the Honorable Supreme Court is saying is, this invoking 370 clause 1D is not relevant. Recourse must have been taken to the procedure contemplated by Article 370 clause 3. If Article 370 is ceased to operate or is to be amended or modified in its application to the state of Jammu and Kashmir, para 2 of Constitutional Order 272, para 2 of Constitutional Order 272, by which Article 370 was amended through Article 367, is ultra vires. Article 370 clause 1 subclause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. In this, what they are saying is the Honorable President has made, by virtue of Constitutional Order 272, para 2 of Constitutional Order 272, by which the entire Constitution of India applies to the state of Jammu and Kashmir. By invoking which provision the President has done it? The President has done it by invoking the provisions of 370 clause 1 subclause D. But the Honorable Supreme Court has held that is not the correct provisions. That is not the correct provision. Then which is the correct provision? That you will find the answer in the coming paragraph. The exercise of power. I am reading para 531.8. The exercise of power by the President under Article 370 clause 1D to issue Constitutional Order 272 is not mala fide. Is not mala fide, though the President has invoked the wrong provision of the Constitution, but it is not mala fide. Number one. The President, in exercise of power under 370 clause 3, can unilaterally issue a notification that Article 370 ceases to exist, meaning thereby the President need not wait for the recommendation of the Constituent Assembly to declare that Article 370 will cease to exist. So since Constituent Assembly got dissolved, where will we get the recommendation? We will not get the recommendation. So that proviso has become redundant. That proviso has become dead. But the main provision which empowers the President to abrogate Article 370, he can do it unilaterally. He need not wait for any recommendations. The, the President did not have to secure the concurrence of the government. The President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second proviso to Article 370 clause 1D, while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Article 370 clause 3, for which the concurrence or collaboration with the state government was not required. See, now the Constitutional Order 272 is under challenge. What is the 272? Para 2 says the entire Constitution of India will be applicable to the state of Jammu and Kashmir. So Constitution of Jammu and Kashmir has become redundant by effect of Constitutional Order 272. But the President's Constitutional Order, by invoking 370 clause 1D, is not mala fide. That is the incorrect provision, but it is not mala fide. Reason is, the same President has power to do it unilaterally, independently, under Article 370 clause 3. If he can do so, if he has a power under 370 clause 3, there is nothing wrong, though, because it is not mala fide. This is what they have said. Now para 9. Para 2 of Constitutional Order 272, issued by the President in exercise of power under Article 371D. Reason, dear friends, why the Honorable Supreme Court has held 371D, it is not mala fide, because 371D prescribes two conditions. The President can act with consultation with the state government. Thereafter, concurrence from the state government. But state government is not there. It was the President's rule. Therefore, no concurrence, no consultation was needed. So, but if the Honorable President is invoking 371D, the procedures are, they need to take the concurrence and consultation from the state government. So having not complied with, therefore Constitutional Order 272 is not valid as per the petitioners. But the Honorable Supreme Court has held, see, if you challenge that President has no power, there is a separate criteria to consider. But 370 clause 3 provides power to the President. He can unilaterally, independently declare that abrogation of Article 370. If he can do so, why not under 371D also? So, para 2 of Constitutional Order 272, issued by the President in exercise of power under Article 370 Clause 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. This is where the authoritative pronouncement, dear friends. To arrive at this conclusion, 282 pages are discussed. By upholding, the Constitutional Order 272 is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. Here the Honorable President by one stroke of pen has declared that entire constitution will apply. It was not done in piecemeal. For example, part 1 to part 5 will be applicable from such date to such date, and the remaining parts will be applicable to the state of Jammu and Kashmir from such date to such date. That is not there. By para 2 of Constitutional Order 272, the entire provisions of the Constitution of India made applicable. Though it was not made in piecemeal, though it was made in entirety, that is not a good ground to challenge the Constitutional Order 272. Therefore, it is valid. I repeat, dear friends, para 2 of Constitutional Order 272 issued by the President in exercise of power under Article 370 Clause 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not mala fide, merely because all the provisions were applied together without following a piecemeal approach. Para 10, para 539.10. The President had the power to issue a notification declaring that Article 370 Clause 3 ceases to operate without the recommendation of the Constituent Assembly. So, the President can do so without the recommendation of the Constituent Assembly. Number 1. The continuous exercise of power under Article 370 Clause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370 Clause 3 is a culmination of the process of integration, and as such is a valid exercise of power. Thus, Constitutional Order 273 is valid. So, what is Constitutional Order 273? Abrogation of Article 370, meaning thereby special powers provided to the state of Jammu and Kashmir is taken away. By virtue of Constitutional Order 273. The challenge to 273 was President can act only based on the recommendation of the Constituent Assembly. So there was no recommendation because Constituent Assembly got dissolved. The proviso has become redundant. But according to the petitioners, even 370 Clause 3, entire 370 Clause 3 has become redundant. That is what their submission is. But the Honorable Supreme Court has divided the proviso separately, provisions separately. Proviso says Constituent Assembly can make a recommendation to the President. That is redundant. That is dead. So now, without even the recommendation, the President can act independently. He can declare, he has the power and he can declare by public notification that this article shall cease to operate, which he has done, and that is valid as per law. 531.11, dear friends. The Constitution of India, dear friends, please listen very carefully. The Constitution of India is a complete code. We say civil procedure code is a complete code for civil procedure. The Constitution of India is a complete code for what? For constitutional governance. Following the application of the Constitution of India in its entirety to the state of Jammu and Kashmir by Constitutional Order 273, the Constitution of the state of Jammu and Kashmir is inoperative and is declared to have become redundant. Para 12. The views of the legislature of the state under the first proviso to Article 3 or recommendatory. Now, the Honorable Supreme Court is moving on to the bifurcation of state of Jammu and Kashmir into two union territories, Jammu and Kashmir and Ladakh. So, the views of the legislature of the state under the first proviso to Article 3 or recommendatory. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala fide. So, Article 3 of the Constitution, the President by law can make a new state also. It can extend the territories also. They have the power. When they are dividing the state, the definition is state includes union territories. That is what the explanation says. So when it is being bifurcated, the views are sought from that particular state. What do you say? Because ultimately they are going to face the ground reality. So the views are required. Such views are not taken in the state of Jammu and Kashmir. So now the Honorable Supreme Court has held those views from the state government are only recommendatory in nature. You may seek the views, you may not seek the views. So the President can bifurcate the state into two union territories without even the views from the particular state government, because those views are only recommendatory and not binding on the President of India. I repeat, para 531.12, the views of the legislature of the state under the first proviso to Article 3 are recommendatory, meaning thereby it is not binding on the President of India. Thus, Parliament's exercise of power under the first proviso to Article 3 under the proclamation was valid and not mala fide. So, bifurcation into two union territories is valid and not mala fide. Para 13, 531.13 point. The Solicitor General stated that statehood of Jammu and Kashmir will be restored except for the carving out of the Union Territory of Ladakh. In view of this statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the union territory of Ladakh in view of Article 3A, read with explanation 1, which permits forming a union territory by separation of a territory from any state. So, Lordships has said, by observing the submissions made by the Solicitor General, that statehood of state of Jammu and Kashmir will be restored. That is what the submission made by the Solicitor General. With respect to the Ladakh is concerned, they have upheld the division of into union territory. I repeat, the Solicitor General stated that statehood of Jammu and Kashmir will be restored except for the carving out of the union territory of Ladakh. In view of the statement, we do not find it necessary to determine whether the reorganization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under 3. However, we uphold the validity of the decision to carve out the union territory of Ladakh in view of Article 3A, read with explanation 1, which permits forming a union territory by separation of territory from any state. Para 14, we direct that steps shall be taken by the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 30th September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The writ petition and special leave petitions are disposed of in the above terms. Pending applications, if any, stand disposed of. So ultimately, dear friends, the Honorable Supreme Court has upheld the action of the President. By the President of India abrogated the special powers provided to state of Jammu and Kashmir. That was challenged before the court of law. Ultimately, the Honorable Supreme Court has upheld the action of the President. So this is what the entire aspect. So while summarizing it, the President's power under Constitutional Orders 272 is valid. Constitutional Order 273 is also valid, and abrogation of Article 370 is valid. So that is the goal by which entire steps, entire points were discussed. So thank you so much, dear friends, for your patience hearing. I am deeply obliged and grateful. Thank you.